Hello student, welcome back to Herbal Drug Technology and Regulatory Science. Last time we have learned about the TKDL and introduction to the IPR. Now we will see some of the case studies where we have understood how the TKDL was helpful. Neem patent case. Many patents were granted by the patent office in those countries based on the properties of neem, that is Azadirachta indica, from 1994. The European Patent Office (EPO) granted a patent to the US Corporation W.R. Grace and US Department of Agriculture for the method of controlling fungi on plants by the aid of a hydrophobic extract of neem oil. This knowledge was considered to be a new by the patent office, but in accordance to the Indian traditional knowledge, this knowledge was used from the centuries by our agricultural processes. This was challenged by several non-government organizations with the result that the patent was revoked in 2000. India developing a database which will act as a form base for such traditional knowledge, and that come under the TKDL. A list of more than 200 cases up till now got a rejection or withdrawal or got amended because of the knowledge sharing from TKDL. A next case is a turmeric case. It is very basic and eye-opening case for rest of the world. One of the most publicized case in that of patenting of wound healing property of turmeric, that is Curcuma longa, by two scientists of Indian origin in United States in the year of again 1994. What they have done, that known knowledge from the Ayurveda and Siddha system, they have applied and they have developed a formulation and the technology for the wound healing property of Curcuma longa, which is halad or haldi. The Council of Scientific and Industrial Research (CSIR) challenged the grant of the patent before the US Patent and Trademark Office (USPTO) and proved that it was an existing knowledge. This case brought attention of entire world towards the traditional knowledge system, and then TKDL came into the focus. A next candidate is a basmati rice case. In year 1997, the USPTO granted a patent to the Rice Tech Inc. USA for basmati rice line and grain, claiming novel rice variety and method. India and nearby Pakistan protested, arguing that basmati is a century-old traditional variety cultivated in Indo-Gangetic plains and not a novel invention. Prior to TKDL, traditional knowledge and historical evidence regarding basmati's existence, cultivation and characteristic were scattered in local text and farmer practice, making it hard for foreign patent examiner to access or understand. Where such knowledge, when they have included in TKDL, it was easy for examiners under one platform to get such knowledge. Although the initial basmati challenge late 90s to 2001 occurred before TKDL was fully operational, the controversy was a key catalyst for establishing the database. This led to a newer term called biopiracy, the unethical or unauthorized use of biological resources, especially plants based with a medicinal value, by corporation, researcher or foreign agency without compensating local communities, is known as biopiracy. Why medicinal herbs are vulnerable to the biopiracy? Indigenous communities possess rich traditional knowledge about the healing properties of the herbs. Most of this knowledge is passed down orally and not formally documented. The foreign corporations and researchers take the advantage of this loophole. Foreign companies can easily patent compounds, extracts, or processes derived from these herbs. Local communities lose economic benefits, cultural ownership, and recognition for their century-old knowledge. That also lead to get a lesser benefit from the business or commercial angle of such herbs. The example of such are turmeric, neem, ashwagandha, basmati variety, hudia, rosy periwinkle. The two unique cases we will discuss here. The rosy periwinkle from Madagascar. The plant used traditionally to treat diabetes. Foreign pharmaceutical companies developed anti-cancer drug vincristine vinblastine from the same plant, and no financial benefit was given to the farmers or to the local who have used this plant from the centuries for the similar kind of a treatment. The first picture you can see of a periwinkle. Hudia, which is a cactus type of a variety. Traditionally, it is used by the South African country by San tribe to suppress hunger during their long hunting period. This was the ability of the plant source, what they used it against its anti-diabetic and weight loss control treatment. Patent by a foreign researcher for weight loss given for the same medicine. After protest, benefit sharing agreement were introduced. Such cases are registered when under the TKDL they get benefit against the biopiracy, and that will give a advantage for the cultivation of traditionally known herbal drugs. Local communities and nations lose revenue while corporations profit from patented herbal medicine. Traditional knowledge is exploited without respect or credit. Countries lose control over their own biodiversity and indigenous knowledge system. To protect the biopiracy or to protect the traditional plants from the biopiracy, the Biodiversity Act was introduced later. Overharvesting of a patented or commercially valuable herbs can endanger native species, which was seen in case of a few plant material where their overharvesting or patented or commercially valuable herbs can endanger native species, which has been seen for few plants where their overharvesting have removed their existence from the nature. So, to prevent this, the preventive measures was needed, and originally the proper disclosure of a traditional knowledge is the biggest step for preventive measure. Benefit sharing agreement is another approach to prevent such biopiracy. Ensuring local communities receive compensation in the form of money or in a profit share. There are few protocols was signed like CBD or Nagoya Protocol. Educating indigenous groups about legal protection and intellectual property rights. After Biodiversity Act, the Government of India introduced the different centers in the local rural areas where the duties of the agent is to gain the such traditional knowledge and the cultivation procedure and get registered on the local forum, so that tomorrow such herbs will not get a biopiracy victimized. Bioprospecting. This is a newer approach towards the few herbal drugs whose activity or their knowledge is extended towards the newer area of a disease. Systematic search for valuable biochemical and genetic resources in nature, especially for medicinal, agricultural and industrial use, is known as a bioprospecting. Focus on medicinal herbs, identifying plant species that contains therapeutic compounds such as alkaloids, flavonoids, terpenoids, tannins, glycosides, etc., which can be used for different purposes other than its known use from the authoritative textual references. It helps to discover new drug, bridges traditional knowledge with modern scientific research. The example of this is our dicerin. A dicerin is a molecule which is used for anti-arthritic purpose. Later on, it was also observed that the synthesis of a dicerin may be easy in a fewer steps if we use a raw material as a sinucide, which has a similar kind of a structure. Contributes to pharmaceutical innovation and biodiversity conservation. Earlier we have discussed how the biodiversity is effective to gain a new drug, and if the over harvesting can create the endangered species. If we can bioprospect some of the drug for unknown disease conditions, then it will be easy to maintain such endangered species. Over the 80% of the world rely on partly medicinal plant for still their daily disease treatment and control. What is the process of bioprospecting? The first step is ethnobotanical survey, collecting information from local healers and indigenous communities about the medicinal plant uses, identifying species traditionally known for treating specific diseases. Second step is a laboratory screening. The data what they have procured from the traditional system or the practitioner need to be evaluated. Phytochemical analysis to detect active compounds, bioassays to test antimicrobial, anti-inflammatory, antioxidant, anti-cancer, antiviral and such various activity is done. Then the isolation and characterization of a compound using chromatographic and spectroscopic technology and molecular tools. This will help to understand the molecule and its activity towards particular disease condition. Determining the structure, potency and safety of the bioactive molecule is on a priority in such exercise. Preclinical and clinical testing, toxicity testing on cell culture and animal model is essential, as we are not dealing with a traditional extracts, but we are dealing with isolated compounds which treated as good as an active pharmaceutical ingredient, so that the toxicity data and safety data becomes mandatory. Human clinical trials for dosage, efficacy and safety is done with the Schedule Y requirements. Product development for herbal medicine in the form of ointment, tablet, capsule or any other novel drug delivery system is done to get it commercialized. Once the commercialization of such product take place, the profit share is back invested to the getting some more type of or some more kind of the herbal products, and they can be used or they can be considered for the bioprospecting. Thank you and have a great day.